Welcome back to the Deep Dive. Today we're looking at a really crucial piece of law, the Judicial Service Commission Act, the 1994 one. Yes, basically the rule book for keeping judges accountable. Our mission today, to kind of demystify it for you. Because, look, judicial independence is vital, right? Judges need to be free. But that independence needs accountability alongside it. And this act, well, it's the blueprint for trying to get that balance right, which is, let's be honest, incredibly difficult.
It really is. And, it's important to understand where it comes from legally. The Constitution itself set up the Judicial Service Commission, the JSC. But the Constitution is quite specific, quite narrow on why you can remove a judge. It's only for incapacity, gross incompetence, or gross misconduct. That's it. So this act then builds the actual machinery around those grounds and lays out how you investigate a complaint, how it's all managed, making sure there's due process.
Okay, right. So let's unpack that core purpose then.
Yeah.
The act itself says right up front, it's about finding an effective balance, protecting judicial dignity and independence on one side, but also upholding openness, transparency, accountability for the public on the other. It's trying to be sort of a safety net and a fair process all rolled into one.
Exactly.
So to get that fairness, the Act didn't just rely on the big JSC. It created, well, new layers, didn't it? More specific structures just for conduct issues. What are these new layers? How do they, fit together?
Yeah, so there are basically two main new bodies set up just for complaints. First, you've got the Judicial Conduct Committee. The JCC, think of the JCC as the first stop, the intake, the filter. It's chaired by the Chief Justice.
Yeah.
And significantly, it also includes the Deputy Chief Justice and 4 other designated judges. And importantly, at least 2 of those 4 have to be women.
Oh, that's interesting. That requirement for, well, gender diversity right at that top level of oversight. Is there any sense that this has actually changed how the JCC works, or is it more about just ensuring representation?
Well, it's hard to definitively measure something like tone,
Yeah.
but it absolutely ensures a wider set of viewpoints. Different experiences are there when they're looking at conduct issues, particularly issues that might touch on gender or social fairness questions. It stops it being just one kind of perspective, and that helps public confidence, I think.
Right.
Now, if the JCC gets a complaint, filters it, and decides it's really serious, hitting those constitutional grounds like incapacity or gross misconduct, then it gets passed up to the second body, the Judicial Conduct Tribunal. The tribunal is, well, it's a heavy hitter, the main investigative body for the really serious stuff. It's made up of 2 judges, one acts as the president, and crucially, 1 non-judicial member, someone from outside the judiciary.
Okay. And the Chief Justice is still overseeing the whole commission and that initial committee, the JCC.
Yes.
But the real check, the sort of external accountability, that comes back to Parliament, doesn't it?
Absolutely. That's key. The Act makes the JSC report to Parliament every year. And it's not just a quick summary. It has to be comprehensive, detail everything the JCC and any tribunals have dealt with, plus updates on things like financial disclosures. So yes, the judiciary handles the investigation internally, but Parliament gets the full picture, ensures public oversight of the whole system.
Right. So we've got the who and where of accountability sorted. Let's talk about the what. What exactly are judges held accountable for? This must bring us to ethics, financial stuff.
Correct. The main standard is laid out in the Code of Judicial Conduct. This code isn't just an internal guideline. It's compiled by the Chief Justice, needs the minister's okay, and then Parliament has to approve it. So it carries real weight. It covers behavior both in court and, outside.
And beyond just behavior, what about outside work? Can judges have side hustles?
Well, the Act is pretty strict on that. Section 11 puts a clear restriction on other work. If a judge is in active service, they generally cannot hold any other office of profit. Basically, no other paying job. It's about preventing conflicts of interest or even the appearance of one.
Any exceptions?
The main one is for royalties, like if a judge writes a legal textbook. But even then, they need written permission from the minister, who has to consult the Chief Justice first.
Okay, now this is where it gets really interesting, I think, for people focused on transparency, the whole financial disclosure part.
Yes, Section 13. It mandates a formal register of judges' registrable interests. There's an official registrar appointed to keep it.
And this isn't just the judge listing their own shares or whatever. It seems much broader.
Oh, it's significantly broader.
Yeah.
The Act requires disclosure of all specified registrable interests, not just for the judge themselves, but also for their immediate family members.
Wow. Who counts as immediate family?
It's defined pretty widely. Spouse, civil, or life partner, any dependent children, and actually any other family member who lives in the same household.
So it casts a very wide net.
It has to, really. The idea is to prevent a situation where a judge might be influenced by interests held indirectly through family, people they share finances and major life decisions with. The specific things that count as registrable interests have to be defined in regulations made by the minister.
And how is privacy handled?
Well, the register itself is split. There's a confidential part and a public part. So it tries to balance that need for transparency with some level of personal privacy. It's an internal system, yes, but built on principles that can be reviewed publicly.
Okay, let's walk through the process. Say you, listening now, believe a judge has, breached the code or acted improperly. How does it actually start?
You'd lodge a complaint formally with the chairperson of the JCC or someone they delegate, and it has to be concrete. You need to submit it as an affidavit or an affirmed statement. This isn't about anonymous tips or, venting on social media. It has to be a sworn statement.
Right, a proper legal basis.
Exactly. And the complaint needs to be based on specific grounds laid out in the Act, like gross misconduct, maybe a breach of the code, conduct unbecoming of a judge. Then comes the first really critical step, filtering out the minor stuff. The chairperson must summarily dismiss a complaint if it's clearly, say, frivolous or hypothetical or just doesn't have substance. And crucially, they must also dismiss it if the complaint is only about the merits of a judgment or an order the judge made.
Okay, hang on. Let's pause there. That's huge.
Okay.
So if I just don't like a judge's decision in my case, I think they got the law wrong, I cannot use this act to complain they're incompetent.
Precisely. That's a fundamental protection for judicial independence built right into the system. Your remedy, if you think a judge made a legal error, is the appeals process. Go to a higher court. Imagine if every unhappy litigant could file a conduct complaint just because they lost. The system would collapse. Judges would be afraid to make difficult or unpopular rulings. So that filter is there specifically to protect the judicial function itself.
That makes a lot of sense. Okay.
Huh.
But what if the complaint is serious? It's not about the ruling itself, it's about conduct, but maybe not quite serious enough for removal from office. What then?
Right. So if it passes that initial dismissal filter but isn't heading towards impeachment territory, it triggers an inquiry into serious non-impeachable conduct. And this inquiry is done in what's called an inquisitorial manner.
Meaning?
Meaning it's not like a standard courtroom battle, prosecution versus defense. It's more like a fact-finding mission. The inquiry aims to find out what actually happened, the truth of the matter.
Okay. And if the inquiry finds the complaint is, well, true, but again, not hitting that super high bar for removal, can anything actually be done?
Yes, absolutely. The committee can impose remedial steps. The focus here is more on correction, maybe institutional learning. The Act lists the options. Things like ordering the judge to get counseling or attend specific training, or more formal steps like requiring an apology to the person who complained, issuing a written warning, or even a formal reprimand.
Does the judge just have to accept that?
No, they have a right to appeal. The judge can appeal the finding itself or the specific remedial step imposed to the full Judicial Conduct Committee.
Right. And it's only if, after all this filtering and potential inquiry, the chairperson looks at it and thinks, okay, this really looks like potential gross misconduct or incompetence or incapacity.
Yes.
That's when it finally gets kicked up to the tribunal, the big investigation.
That's exactly right. That's the trigger for referral to a tribunal, when the path towards potential removal really begins.
Okay, so we're now at the most serious stage, the tribunal.
Correct. The Commission asks the Chief Justice to appoint a tribunal when there are reasonable grounds to suspect one of those big three constitutional issues: incapacity, gross incompetence, or gross misconduct.
And you said the tribunal hearing is also inquisitorial, like the earlier inquiry, fact-finding focused.
Yes, the manner of the inquiry is inquisitorial. But when it comes to deciding if the allegation is actually proven...
What's the standard? How do they decide?
They make their determination on the balance of probabilities.
Which means,
yeah,
for those of us not up on legal jargon,
it means more likely than not. Is it more likely than not that the alleged conduct actually happened? It's the standard used in civil cases, not the criminal standard of beyond a reasonable doubt.
Okay, got it. And the judge being investigated, what are their rights during this tribunal process?
They have full procedural rights. The right to have a lawyer, the right to give evidence themselves, to call their own witnesses, and importantly, to cross-examine witnesses brought against them. It's a thorough process.
And what about that constant tension we keep seeing between keeping things confidential versus being transparent? How does the tribunal handle that?
Well, the default position generally is that the hearings are restricted, confidential. just the necessary people, the tribunal members, the judge, their lawyers, the witnesses while they testify. But there's a specific provision allowing for transparency. The president of the tribunal, after consulting the Chief Justice, can decide that some, or even all, of a hearing must be held in public.
And when would they do that?
The Act says it must be if it's considered to be in the public interest and, for the purposes of transparency. It's a judgment call based on the specific circumstances, balancing the need for confidentiality with public confidence.
Okay, so the tribunal conducts its inquiry, hears evidence, makes its findings on the balance of probabilities. Then what? Where does their report go?
They write up a comprehensive report detailing their factual findings and submit it to the full Judicial Service Commission, the JSC. The commission then considers that report and makes the final authoritative finding. Do they agree there was incapacity, gross incompetence, gross misconduct?
And if the commission says yes, guilty on one of those grounds.
Then that finding goes straight to the Speaker of the National Assembly.
Okay, so this act, this whole structure we've been discussing, it's the detailed procedure that takes a complaint, filters it, investigates it, and if it proves to be one of those serious constitutional issues, it connects it directly to Parliament.
Precisely. The Act provides the formal legal basis for the finding. Then the Constitution kicks in again. Section 177 says Parliament must then consider removing the judge. And that requires a huge political step, a supporting vote from at least 2/3 of all the members of the National Assembly.
Wow. 2/3.
Yeah. So removal isn't just judges policing themselves. It's based on a rigorous legal investigation finding, confirmed by the JSC, but ultimately requires that massive cross-party consensus in Parliament.
Okay. So summing up, this act really creates this quite intricate, multi-layered system. It's trying to protect judges' independence, but also build in real accountability.
That's the core tension it manages, yes.
And it defines the boundaries pretty broadly, doesn't it? Not just courtroom behavior through the code, but also these restrictions on outside work and delving into their private financial lives, even their families' interests.
It absolutely does. It's the procedural bridge, as you said, that makes the constitutional idea of accountability actually work in practice. It sets up these filters, these different levels of inquiry, all designed to get to the truth while respecting the judge's position, but ultimately protecting the public interest.
Right. And as we wrap up, maybe a final thought for you, the listener, to mull over. The Act takes this whole process very seriously. How do we know?
Yeah.
Well, look at the penalties baked into it for messing with the system.
Ah, yes, that's quite striking. If someone, anyone, is convicted of deliberately giving false information to the tribunal, or maybe leaking confidential information without authorization,
What happened?
they face a pretty hefty penalty, a significant fine, or even prison time, for up to 5 years.
5 years. Just for procedural offenses around the tribunal.
Exactly. So the provocative question for you is, what does that severe penalty tell us? What does it signal about how sacred, how protected these internal judicial oversight processes are considered to be? Something to think about.